Good afternoon, everyone. My name is Matthew Morantz. I'm the outgoing co-chair of Young ICCA, and I'm here with Shireen Gordova, the new co-chair of Young ICCA, as well as Manas Jain and Maria Tanaziu. We're very happy to welcome you to today's event. After a few very intense days here in Edinburgh, we decided that we would try something a little bit different. So I'm hoping that you'll join us in this adventure. It's going to be a three-part adventure. The first part of this adventure, we're going to ask you to place yourselves in the future. The year is going to be 2032, and we will be hearing a debate on the motion as follows. The old approach to witness evidence is no longer fit for purpose. That's coming up just now. In the second part of our adventure, after a short coffee break, we're going to be running what's called the Shark Tank. And for those of you that don't watch TV, a Shark Tank is a TV show that involves business presenters pitching to a panel of investors and trying to persuade them to invest in their companies. Now, for our purposes, the Shark Tank is going to involve very senior practitioners, and the pitchers are going to be younger practitioners making presentations to try and persuade the sharks that the most important arbitral decision in the past 4 years is the one that they're presenting. So, third and perhaps most importantly, at the end of the event, we'll be holding a cocktail, which is generously sponsored by DLA Piper. Before we begin, just a few words about Young ICCA. Oh, sure. I think we have some slides, but not sure who's in control of the slides. Okay, I think, yeah, there we go. So Young ICCA was founded in 2010 by Lise Bozeman, Marieke Paulsen, and Eduardo Damio Gonzalez, and it's now over a decade old. There are 10,000 members spread out throughout every corner of the world, and Young ICCA provides 4 streams of programming and activities free of charge to all its members. In terms of events, which is the first of the pillars up here on the screen, we organize a number of workshops throughout the year that are focused around the development of skills that are critical to the practice of international dispute settlement. The branch of our activities events is run by 2 of our wonderful co-directors, Anna Coimbra-Trigo and Sami Kim, both of whom greatly contributed to today's event, so thank you to them. Up here on the screen, you can see as well another branch of our activities, which is scholarships. We run 3 different full tuition scholarship programs to the Miami University graduate program in international dispute settlement, the MIDS program in Geneva, and the Tsinghua Law School program in China. Now over to you, Sharon, to talk a little bit more about our 2 other branches of programming.
Thank you. Thank you, Matthew. Third, we coordinate a mentorship program, which probably many of you know about. It connects small groups of young ICCA members with leading practitioners for 2-year cycles. Applications for this mentorship program open every year in the middle of summer. And the application process for 2023-2024 closed recently in August. And we will be opening the mentoring program applications in summer of 2023 for 2024-2025 cycle. So the program is co-directed by Crystal Batista, Emily Hay, and Peter Riesnick. Bravo. And all current Young ICCA members are eligible to apply. The program is best suited to young professionals interested in international arbitration. In selecting Young ICCA members for participation in the program, Young ICCA aims to achieve a broad diversity and a wide geographical distribution, including appropriate representation of mentee applicants from countries that are underrepresented in the field of international arbitration. Applicants must have completed an initial law degree by the time they start the program. Fourth, we have an editorial branch, which runs various projects, including the Young ICCA essay competition. This branch is co-directed by Juliana Iancu and Nicolas Poon. Another round of applause for them. Thank you. Our most recent essay competition was on confidentiality in international commercial arbitration. On the theme of confidentiality and international commercial arbitration undermines the legitimacy of the process. The winner of this competition was awarded a slot at the ICCA Congress, where she presented her paper and spoke alongside very accomplished practitioners. We received more than 50 high-quality submissions for that competition, and the winner's name is Lilit Nagapetian. You've probably met her already and listened to her presentation. Lilit is a trainee lawyer at Candy Law LLP and PhD candidate at Queen Mary University in London. In addition to the essay competitions, we also ran Successful Young ICCA blog. We ran the Successful Young ICCA blog. At the moment, it is being remodeled and remodernized. So please stay tuned for that. We have lots of interesting ideas for that, for reviving that blog. And now I would like to say a few more things about our parent organization, ICCA. For those who don't know or who haven't participated in the ICCA Congress, ICCA it stands for the International Council for Commercial Arbitration and was formed in 1961 to promote greater knowledge and understanding of international arbitration worldwide. ICCA's bureau is based in The Hague at the Peace Palace. Its activities include publication of authoritative publications like the annual yearbook of commercial arbitration and collection of country reports for the ICCA handbook. It also includes organization of biennial congress, which is the largest regular event dedicated to international arbitration, and we have participated in one in the last few days. Also, it includes facilitations of trainings for judges on the application of the New York Convention and operates a wide variety of projects tackling current issues in the field. So if you are above 40 and are not a Young ICCA member anymore, consider applying for membership at ICCA. So that being said, I would like to move to the introduction of our moderator, which I do with great pleasure and honor. Our moderator today is Panos Chalkias. Panos is an associate at White & Case's offices in Geneva. His practice includes advising and representing clients in complex, high-value, cross-border disputes in a variety of industries under all major arbitration rules and governed by various substantive laws, both under common and civil law. Previously, he worked as an associate at an international arbitration boutique in Brussels and at the World Intellectual Property Organization Arbitration and Mediation Center in Geneva. Panos is a former co-chair himself. He held the office along his co-chairs at the time between 2019-2021. He has been recognized by Who's Who Legal Arbitration Future Leaders 2021. Panos speaks Greek, English, French, and Spanish. And we are very honored to have you today, Panos. And without further ado, the floor is yours. Thank you.
Thanks. Thank you, Shirin, for this kind introduction. And thank you to ICCA and the Young ICCA for making this event possible. I was going through my emails the other day and I realized that Young ICCA started organizing this event in mid-2019. But as with the Congress, this event had to be postponed several times. So I'm very happy and excited to be here with you today and to moderate today's panel. Today's topic is Back to the Future Inspired, as Matthew has mentioned. Our speakers have the challenging task of predicting what the practice of taking witness evidence in international arbitration will be in 10 years' time. Good luck with that, I have to say. All I can predict about 2032 is that there's going to be a new iPhone and that probably people will be complaining that it looks like the previous model. But joking aside, if we're talking about today's practice of taking witness evidence in international arbitration, I thought I should mention the ICCA report on the accuracy of fact witness memory in international arbitration, which was issued in November 2020 and is publicly available. This report provides an insight into the science of human memory, which we know is imperfect and can be distorted, and discusses, among other things, how the practice of taking and presenting witness evidence in international arbitration can be improved. No doubt, those same issues will be discussed during today's debate. Coming now to our speakers, I can only describe them as excellent. Beyond their experience and legal credentials, they have all acted both as counsel and as arbitrator, and it will be interesting to see whether their views will change depending on whether they're wearing the hat of an arbitrator or the hat of counsel. But following an alphabetical order, I'll start with Gloria. Gloria Alvarez is a senior lecturer at the University of Aberdeen, where she teaches, among others, international commercial arbitration and international investment law. She's an international arbitrator, academic, tribunal secretary, and expert in the areas of dispute resolution, energy, and international investment. She has worked as an in-house lawyer in a transnational company and as a case manager at an arbitral institution. She has held prestigious academic posts at the University of Cambridge, Queen Mary University of London, Max Planck Institute, and her book publications include the ICCA Convention, a practical commentary, and International Energy Arbitration in Latin America. Both of these books have been published by Kluwer. Gloria was also a Young ICCA mentoring program coordinator, and I can confirm that she greatly contributed to the program's success. Finally, Gloria sits at the editorial board of ICCID Review and is a faculty member of the CERB diploma. Our next speaker is Nusha Basiri, and I have a quick disclaimer here. Nusha and I used to be colleagues for more than 6 years, so in all objectivity, I will say that she's a great person to work with and a wonderful mentor. Disclaimer aside, Nusha is a partner at Hanotiu & Vandenberg in Brussels. She acts as counsel and arbitrator in international arbitrations under various arbitration rules governed by diverse substantive laws and spanning a multitude of sectors. She's also a sought-after strategic advisor on setting aside and enforcement matters, in particular under the New York Convention regime. Recently, she has been nominated as a mediator too. She's a member of the faculty of the Miami LLM in international arbitration and a visiting senior fellow at the Singapore Faculty of Law. She regularly speaks at leading conferences and seminars and publishes in the field of international arbitration. Her peers and clients have praised her excellence in international arbitration for over a decade, and with good reason, if I may say so. And she regularly is listed in all major professional rankings. To the left of Nusha, we have Tiffany Compress. Tiffany is a partner at Fisher Broyles in Miami and Paris. She serves as counsel and arbitrator in international arbitrations under all the major arbitral institutions and rules, as well as certain industry-specific institutions. As counsel, she represents global and domestic companies in various sectors with particular experience in international agriculture, food and beverage, and logistics, among others. Tiffany is one of only 3 attorneys board certified by the Florida Bar as an international expert on international law and international arbitration and litigation. She has been recognized as an expert on the CISG and the Perishable Agriculture Commodities Act. She has written for several leading industry publications in agriculture and arbitration, and she was recently interviewed by Young Arbitration Review about the CISG and arbitration. She's a regular guest lecturer at the University of Miami on the CISG, and is listed in numerous major professional rankings. Last but not least, we have Baiju Vasani. Baiju is an international arbitration lawyer and arbitrator based in London and has recently joined 20 Essex. For over 2 decades, he has served as advocate or arbitrator in high-value international arbitrations across a range of sectors and industries. He has also advised states on the negotiation and drafting of investment treaties. He has an active pro bono practice using international dispute resolution techniques to further the global rule of law, and is passionate about bringing diversity into the international arbitration field. Those who have read his LinkedIn posts know that he's also a big supporter of the younger generations of international arbitration practitioners, sharing his tips on how one should apply for international arbitration positions. He lectures on international arbitration at the SOS University of London. He is also a fellow of CIARB and on the arbitrator panels of several institutions, including ICCIT. Finally, he too has consistently been ranked in international arbitration by all the leading directories. And one of the quotes I've chosen for today's debate is that he can win over any crowd thanks to his brilliant oratory skills.
No pressure.
No pressure, exactly. So in terms of structure, Nusha and Tiffany will go first, arguing in favor of the motion. That is that in 2032, the old approach to witness evidence will no longer be fit for purpose. Gloria and Baiju will go second, arguing against that motion. Once the first round is complete, each team will have a short rebuttal, focusing on the arguments of the other side. And following that rebuttal round, we will open the floor and we'll take questions from the audience. Now, before we start, I thought that we could already have a quick poll and have a quick show of hands. So who thinks that in 2032, the old approach to witness evidence will be a thing of the past? All right. And who thinks that we will still follow the same approach in 2032? Okay. 50-50, I would say yes, it's a bit balanced. So interesting. Let's see how things will change after the debate. So thank you very much. And Nusha and Tiffany, over to you.
There is no actual Garden of Eden, of course. As with so many in our ancient scriptures, the story is meant to be read as myth. But the myths are not, in quotation mark, false in the way we understand the world today. The significance of a myth rests not in any truth claims it makes, but in its ability to convey a particular perception of the world. The story of the Garden of Eden, like the numerous flood narratives in the ancient Near East or the tales of gods who die and return to life, represents a special class of myth called folk memory. There are universal myths predicated on the collective memory of a particular culture or society and passed down orally from generation to generation. They can be found in some form in almost every religion and among nearly all cultures. That's a quote from a bestseller by Reza Aslan, God, A Human History of Religion. And I refer to that not only because it's an amazing book to read, but we are also seeing a resonance in it by Yuval Noah Harari, who also speaks about that humans have, since the Stone Ages, constructed elaborate stories and convinced as many other people as possible to believe in them by telling them often enough and long enough. This is a good thing, Harari says, because fables, myths, sagas, and religions bring people together. So there is an inherent need in us humans, an inherent longing for a good story that we want to memorize, that we want to pass on, and that sticks with us in our minds. I remember my first year at law school in 1993 already. The University of Cologne, the legal history professor, taught about the foundational statements on the separation of powers, of course, by Montesquieu. And he told that foundation of separation of powers by telling a story as if he was there himself in 1748 with Montesquieu. And he told it as a really nice story. That's why nearly 30 years later, I can still remember it. So how disappointing is it then when really good stories are brutally crushed, demolished, or even evaporate? And more disappointing, or actually more than disappointing, how dangerous is it for a party in an international arbitration when it happens to their so-called star witness during examination? The star witnesses were supposed to tell the story and to help the party to win the case. I can tell you from an anecdote where one party thought they had a star witness who was actually a defected witness. So that witness was actually affiliated to the one side, then went over to the other side. And the cross-examination lasted not longer than, I would say, 1.5 minutes, because the only question that was put to that witness is, how much did you get paid for this evidence today? And because it was a rather substantial amount, the counsel rested his cross-examination. The tribunal didn't question the witness further anymore. I myself have been a witness, and I don't know how many of you have gone through that experience. I can tell you it is very terrifying. And I have been in that situation as a trainee lawyer already. So not as a lay person, but as someone who knows about testimony about witnesses. So how and why do we put so much emphasis on the witness testimony? When the tribunal can put questions that counsel do not dare to ask, and with that also, in fact, decrease the value, if not even completely nullify the value of the witness. And we know from many, many studies that how the brain works, that witnesses actually not much tell the truth, but rather that what they think should be or should have happened. And the studies are mentioned in excellent articles and lectures. The article by Jennifer Kirby on the storytelling by witnesses already from 2011, by Toby Lando and his Kaplan lecture of 2010, which then was apparently also an inspiration for the ICC to pick up the ICC task force and then produce the 2020 report on accuracy of fact witness memory in international arbitration. So why do you want to impose so much pressure on a human's brain and expose that brain to scrutiny? Should the really good storyteller not be rather an advocate? My colleague will tell you why.
Indeed. There is a quote from Ursula Le Guin, which I don't recall to the letter because my memory is very fallible. But she said to the effect that sophisticated societies have always existed without the wheel, but no sophisticated society has existed without stories. So stories are crucial, but they are for the advocates, for the professional to tell. I can't tell you the number of times that I've seen. In fact, I had a hearing as counsel before I was acting as arbitrator, where I had this witness that prepared beautifully. He was really testifying as to one of the linchpins of our case, And we prepped him. He was excellent. He had everything, all the dates memorized. Everything was in accordance with the facts in the papers. But when he got into the hearing room, he completely fell apart. And there are sometimes not much that you can do as a counsel. Witnesses are going to say what they're going to say. And for this reason, I think we should have no more witness statements at all. We find that witness statements and witness testimony is a minefield. They're unreliable, as Kirby and others have discussed, per my colleague. They will unconsciously feel pressure to align their testimony with the case. Oftentimes, as an arbitrator, I can tell you, just as with the extremely aggressive argumentation in submissions, I gloss over it. I'm not reading that stuff. I'm looking at the facts. I'm looking at the cases that you're citing. I'm looking at the evidence. And by their very nature, witness statements are taken with a massive grain of salt and a significant amount of skepticism. Usually it's very clear that they're produced by counsel, not by the witnesses themselves. And that, of course, adds to the drop in credibility. What we propose is that parties offer witnesses to the tribunal. The tribunal selects the witnesses that it is interested in hearing. The tribunal actually poses the questions to the witness. The counsel has an opportunity afterward for very limited questioning, perhaps to clarify something, in particular, something like that. But really, the arbitral tribunal is to take over. And this is very much more of a style from civil law, not as much in the common law. In the common law, as we know, you'll see counsel that really lead the drive here. But this will have two effects. One effect will be to involve the tribunal at an earlier stage. In fact, why even wait until the final hearing? Perhaps you can hear some witnesses earlier that could help narrow the issues, right? But critically, this will achieve more truth and justice as between the parties, right? If the goal, as an advocate, yes, my goal is to persuade, but that's my goal, and that is as an advocate, that is my duty, right? That is my task, and that is my skill. It's not the witness's skill. It's not their task, and it's not their job. Their job is to report the evidence. We believe that they should be prepared, reminded of the facts, see the documents. You don't want a witness to be on the stand looking at a document for the first time in 15 years. That's not very helpful. But it really should be the tribunal that chooses from whom it wishes to hear. This has benefits also, and quite importantly, to the parties and to counsel, of preserving resources. It's a waste of resources to spend time on this witness statement that won't be read by the arbitrator at the end of the day, not in the detail in which counsel would like. It will shorten the papers that are required, will shorten the time, shorten the length. Counsel has a propensity to bring across many, many witnesses that are not really necessary to the facts. And we believe that this will shorten that process and help streamline the arbitration. Anything you'd like to add?
Yes. So just one thing about the cross-examination that looks so fancy, and I'm sure Jude is very good at that. But it's, again, a heavy influence of the United States trial system. I know you have it also in England. But the documents speak for themselves as well. And a good tribunal is well prepared and will read the documents. And they cannot fail in terms of memory or storytelling. So the motto is NMWS, no more witness statements.
Sorry, I will use a little bit of a Mexican and a English style to reply. My learned friends, if all cognitive or legal scientists were to agree that witness evidence is no longer fit for purpose, I would think that instead of a community of critical thinkers, we somehow have become a sect of corrosive fatalism. And while it is true that electric light did not come from the improvement of candles, it is also true that arbitration enlightenment is the consequence of continued progress. My hypothesis for this evening is that there is no such thing as an old approach. Thanks to the will of the parties, the procedural feature of witness evidence has never been static, but rather truly elucidates the principle of progressive improvement. When the foundations of our practice are shaken, we should always revisit our core legal values and remember that, unlike national courts, it is party autonomy what bolsters the ever-evolving perfection of our arbitration practice. And I have two key reasons to illustrate this. First, in a party-led arbitration process, as part of evidentiary planning, parties can request to the tribunal the possibility of submitting preliminary summaries of a witness testimony. This improvement in the last 12 years has served as a medium not only to educate and inform the tribunal, but also to alleviate Tiffany's concerns, has significantly reduced the adversarial mismatch between civil law and common law lawyers. Empirical surveys show that just a very small minority of respondents will be willing to do without cross-examination. Not surprisingly, that minority is mostly represented by civil lawyers. In response, and guided by the development of soft law instruments, more than 12 years ago, the Prague rules have reminded us that party autonomy is also the parameter for a tribunal-led process. For example, a substantive case management conference, or as we know it, CMC, has brought improvements in the way witness evidence is presented, and therefore bringing a sense of equal footing between disputing parties. This means that for those parties that need it, a special CMC is a middle point that can bring clarity to undisputed issues, relief sought, and the legal grounds of each side. And as a matter of fact, that encouraged settlement. And this new CMC feature that we have practiced for the last 12 years has served for either the civil lawyer or the less experienced lawyer as a relief and opportunity to prepare well for the real hearing. Just on that note, the ICCA amendments that took place in 2022 give us fact-finding rules, very aligned with the spirit of the Prague rules. Second, dispute resolution, my friends, is a job of the mind. In other words, decision-making takes place in our cognition. That is precisely why, indeed, my dear Nusha, we are storytellers or case theory tellers. And within the craft of our trade is our duty to maximize that accuracy. Witness evidence has been successful and necessary in order to place documents in a commercial context, as well as plug evidentiary gaps in our narrative. Nonetheless, again, using empirical data, there is no suggestion that the decision-making process of an arbitration tribunal is fully based on witness credibility. Even when deciding exequat bono or amicable compositeur, as part of a due process, an arbitration tribunal will need to consider the commercial contract, the other experts, meaning expert witness, including to listen and to learn about industry practices, the law of the seat, and issues of public policy. Therefore, witness evidence is one of many other elements in striking that balance to give us due process between storytelling and tribunal's determinations.
Thank you, Gloria. The year, as you've heard, is 2032. So I think, first of all, we need to congratulate ourselves on how we look. Not a day older than we did in 2022. So I needn't have worried about my receding hairline or my expanding waistline. We have aged well. What else has aged well is how we take and digest witness evidence. And I'll put to you that there's two reasons why witness evidence has and will have survived in 2032 in the way it has. And there are two pillars that the learned professor next to me has expounded upon. The first is the notion of party autonomy. So that tells us that the parties can have their case as they want it. If they want no witnesses at all, they'll have no witnesses at all. If they want cross-examination of witnesses, they'll have that. They can shape their hearing, their procedure as they want. The second part, and I think this is very important and has been glossed over by my friends on the other side, and that's the concept of due process. And this concept of storytelling is used in a denigrating sense, but it's their day in court. It's when they sit and tell their story, their fears, their woes, what happened to them. And when they lose or when they win, they feel they had a good shot. And if you limit that, then you are limiting their right to have a full and fair opportunity to be heard. As my 13-year-old daughter says now to my wife and I, you do you, boo. That's her little phrase to us constantly, which is you can say what you want to say, right? We want to hear you. You put your case forward and say what you want to say. We're not going to limit you in how you say it, what you say. It's your case. You bring it forward. It's your defense. You bring it forward. Those are two fundamental pillars of party autonomy and due process, that if we start telling witnesses, and often witnesses are claimants, often witnesses are the key people who suffered for decades on a story, to tell them this is what you can tell us and this is what you can't tell us, you are denying them, I would say, party autonomy and due process. Now, what are the concerns? Okay, I'm not immune to the pleas of the other side where they tell us, but witnesses are fallible, lawyers are persuasive, they're kind of making stuff up, they think they're telling the truth, they're not really telling the truth, they're more pleading the case, and they say there's a better way of doing it, because what they want to try and achieve is some sort of ephemeral call to truth. And what I would say is that those issues, I hear those issues, we know those issues, we're woke to those issues, but those issues are already addressed in the current system. And how are they already addressed in the current system? And I'll give you 7, or I'll give my friends 7, and let's see how they address them as we pass the floor. So the first is cross-examination. And we heard, again, some fleeting denigration of the concept of cross-examination, but it's a critical facet. There's a reason that the common law has had the right to confront a witness for hundreds of years, because it's a good way of finding out who's telling the truth. I can ask you a question, and if it turns out that actually you are a myth teller, a folk teller, then that is going to be readily apparent because you won't be able to answer my questions. So that's a good way of separating the folk tellers from the truth tellers. The second are tribunal questions. Okay, you don't like cross-examination? No problem. Let's do inquisitorial system. Let the tribunal ask the questions. And by the way, I am not afraid to ask the questions that you said only the tribunal can ask. No, I'm happy to ask those questions, as I think are most competent cross-examiners. If, in fact, what the witness is saying is nonsense, that's fine. That's up to the party. And then the tribunal will say, I'm sorry, I have no interest in what this witness has to say. As Tiffany said, I'm not going to read their statement. I have no interest. But that is then going to the credibility of that witness, the credibility of the lawyers, the credibility of their party. That's their choice. As again, my 13-year-old will say, you do you, right? You put forward your case. If it's no good, it's no good. We also have to remember that the documents themselves create the house on which the witness statements fall. We have, as Gloria said, the other witnesses who may agree or disagree with what this particular witness said. And finally, the fact is most people want to tell the truth, right? We're human beings. We want to tell the truth. And you have people who try. I'm going to be 30 seconds over with the chair's discretion. So what I'd say is this. Most witnesses I know try and tell the truth. They're careful, they're considerate. They look at that witness statement and says, I don't want to say this. I can't, this, I want this word, I don't like this. They do that. You've done that. You've all been there where the witness has said, I don't like this sentence. Great. Most lawyers are careful. None of us are going to say in a witness statement, I felt I was treated unfairly and inequitably, right? We're not going to put that in a witness statement just because we're trying to do fair and equitable treatment. We want to do right by the people who we're doing, because it ultimately goes to our credibility and the witness's credibility. And finally, I'd say few cases really turn on the question of a witness's memory. How many cases can you think of where the tribunal was like, all else being equal, I believe this person and not this person, and then I award $1 billion? None, right? It's all about the holistic context. So had my friends come to this debate and said, let's take a scalpel and carve around the edges, we would have been very happy to agree. But they are throwing the baby out with the bathwater. And so, Dr. Alvarez, I would say to you, vote against the motion, because in fact the system works and the system is self-controlled. We're happy to have some tweaks, but the system needs to stay.
May I rebut? Where we start here together. Due process. Interesting suggestion that all civil law jurisdictions and courts are not complying with due process because they don't hear witnesses in courts. But we take note of that. I don't think they will amend the procedural rules in all those countries. It's not a therapy session. You want to be heard, go to your lawyer and tell the story. I understand you want to let it out. You want the decision maker to hear your story, but it's also very dangerous. And your own counsel should actually consider whether you really should tell your story there. So it's
just one little comment on that. And let's not forget, I mean, I know my colleague would like to pull your heartstrings and make you believe and think that we're telling, you're depriving them of their day in court. First of all, we're not in court. Our clients chose not to be in court, right? We're in arbitration. And second of all, let's not pretend that we're talking about some individual who had his rights trampled by the US government and has been sitting in Guantanamo. We're representing massive companies for the most part, okay? They're not actually persons. They're false persons. They're imagined persons. So I think we also need to put that in this kind of context.
Right. And the whole debate about cross-examination, you don't have to have a cross-examination to get to the truth. You don't have to have your counsel stay in court to show what an amazing advocate you are, how deadly you can put questions and crush a person there, really like melting away. No, the tribunal can put the relevant questions. The tribunal can ask, give me the context to this SMS exchange and WhatsApp exchange, which happens now more than often than any emails or documents, than in commercial disputes in particular. And so the tribunal can actually make sure and control exactly the due process and right to be heard principles. That is more work for the tribunal. You don't trust your arbitrators? Tough luck. That's where we are. So get your good arbitrators on the panel and make sure that they read the file on time, already well before the hearing, and already preparing themselves for putting the questions. Isn't that actually more cost efficient as well and time efficient? Isn't that the problem about arbitration? That it is so long, it's expensive, and we're not even tackling document production here.
Precisely. And I completely agree with your point. To build on that, I mean, I would say that the real issues that our opponents raise are due process, party autonomy, and efficiency. But these issues are amply addressed by our proposal, as you so astutely noted. In fact, first of all, we already limit the parties, and let's not pretend that we don't. Witnesses, again, are not the most reliable, as our opponent has conceded. Arbitration outcomes don't often turn on witness evidence. So why are we going to take all of this time at a hearing, which is probably one of the most expensive components of the actual process, and spend that time and money on witnesses when the actual outcome is not going to turn on that evidence? Let's focus on what really matters. Most of these cases are based on contractual language. So I think this is much more about focusing due process and party autonomy to lead to efficient and accurate outcomes.
Yes, we're very much on time.
Thank you. About big
Because you have no witnesses.
about big companies and therapy. Okay, I think we have to remember ourselves that law is a social science. And this is, I'm not lying to you. I really hope all of you know that this is a language issue. We are really giving a narrative to the arbitration tribunal. We are not heart surgeons or computer scientists. We deal with words and letters. And that's the reason storyteller is very important. As a matter of fact, in therapy, you heal the legal mind. And the way therapy works is by, if none of you have never been in therapy, I'm very happy to disclose I have. And the way the mind heals is by answering questions to your therapist until you reach a place of mind where you are happy with yourself. This is our field as well. Law is within the social science. This is what we do. That's the reason cross-examination is so important. And about big companies, my experience in international arbitration has been different. I'm starting my career, and as an expert, I have been, with one side, a very sophisticated company indeed that can pay very good lawyers, but I have also been employed by law firms, small law firms, where I am the star of the dispute. And what I say and the way I reply to the arbitration tribunal, it is very important for that client and for those lawyers. And if we pretend that we are only in a system of big companies, I think, my friends, we will leave all the business to Western Europe and some places in Asia. But if we are talking about diversity and inclusiveness, the way we fit and fix international arbitration is from the bottom upwards. And therefore, we have to be very conscious about the value of witness examination and witness evidence.
Let me unpick some practical threads, and then I'll end on two additional principles. The practical points, okay, so the catchphrase that they were hoping that you'd like is NMWS, no more witness statements. Sounds good. I like it. Okay, all right, we don't have witness statements. What do we have then? Well, you have witnesses. They didn't say no more witnesses. There was no more witness statements. So what are we going to have? We're going to have then longer hearings, because at some stage you have to hear what the witness has to say, but not in a statement, apparently, just at the hearing. All right, so we're going to sit there for a direct examination of 3 days. Well, but then you think, okay, well, that's interesting. How am I going to know the case against me? How am I going to prepare cross-examination if I don't know what this witness is going to say? What about the narrowing of the issues, right? You have the witness statement with the memorial or with the counter memorial, and then you have a witness statement with the reply or the rejoinder, which is narrower. You're not going to get that. We're not going to get a funnel effect. We're going to get just a explosive, all over the shop narrative at the hearing. Well, you say, okay, well, but in domestic courts, we have where the witness just comes in sometimes at the hearing. Yeah, but there you have depositions, right? There is still some knowledge of what the witness is going to say before you step into the hearing room. So are we going to have depositions? I didn't hear it. At the end of the day, we do read witness statements. Certainly when I'm an arbitrator, I do read witness statements. Yes, I know that witness memory is fallible. Yes, I know that the lawyer had a hand in the drafting of the witness statement. But I take that into account when I assess its credibility. I read it. Does it sound like the witness or does it sound like the lawyer? I think we're doing a disservice to the arbitrators to say that they can't differentiate between a folk tale written by the lawyer and by a witness in his or her own voice. Let me end on those two principles that I promised, additional to the due process and the party autonomy principle. One is, what are we really trying to do here? If we were a commission trying to find out what happened in an event, right? Something bad happened and we're trying to do a commission of truth, then I'd say, look, we want to do it so we find out what is the actual truth. It doesn't matter about the stories. What's the truth? But actually, dispute resolution is about both parties putting what they say is their story and the third party fact finder deciding, as between those two truths, which one is more likely than not correct on a burden of proof. Not what is the actual 100% truth. In a way, that doesn't even matter. What matters is as between those parties with a burden of proof. The second thing, and I think Gloria touched on this, and this is my final point. And again, they denigrate this as a therapy session. We exist because international arbitration exists. International arbitration exists because when parties lose, they accept they lost, but they got a fair shot. And they got a fair shot because they were heard. And they're heard because we gave them the chance to put their story forward in any fulsome way that they wanted. If we start negating their ability to tell their story in the way they want and say, I'm sorry, I just don't want to hear what you have to say, I think we're going to start getting losers in the international arbitration system who are going to say, they didn't even hear what I had to say. And I think that's a very dangerous place to be.
Well, if we may have a sir rebuttal, because we have 2
The
points.
event doesn't provide for it, but I will allow it.
Thank you.
So then a sir.
Well,
We will never leave this room, you understand?
2 points, and I'll address one, and my partner will address the other. But you have quite been doing 2 things often. I'm going to call you out on them. Straw man argument to the end, right? To the end, since the beginning. You're actually not taking our position as it comes. You're taking a position that you wish we had taken, which is not accurate. And B, you are completely misstating our position, which these 2 things go together. So
I'll let the audience be the judge of that.
So I didn't say I don't read witness statements. I take them with a massive grain of salt, and I will skip over the things that are not relevant, because let's admit these witness statements are often full of things that are not really relevant to the case. So I'll read it, but it's not going into my file in my notes. But more deeply, we're not saying that people shouldn't get their day in court. We're not saying that there should be no more witnesses, that witnesses are not important, and that storytelling is not important. That's not at all what we're saying. But we are trying to achieve an efficiency within this system, because if international arbitration continues to become more expensive and more lengthy, which is what I'm hearing all the time, then certainly no one will choose it, right? We have to realize that we are different from the court system, and we are a chosen strategy. And we can't pretend that we don't already have a format and a rubric in which parties are required to fit in their story. They don't get to say however they want, whatever they want to say, however they want to say it. That's already untrue. So any further refinement of the existing system for the benefit of long-term efficiency and more clear truth-telling could be a benefit. And if the parties agree to it, then they can't turn around and say there's been no due process.
It's not your turn. The longer hearing argument doesn't fly at all. Have you managed to have 27 witnesses in 1 week in an arbitration? No, exactly. But as there were times in civil law countries where lawyers were not allowed to have contact prior to witnesses giving evidence. And a lot of arbitration practitioners have fought for that right with their local bars. The code of ethics were changed, and arbitration for equal arms arguments. They were then allowed to actually have pre-hearing contact with the witnesses. But I actually sat in a hearing where one lawyer, counsel side, at that time Italy, but it's many years ago, things have changed since then, was not allowed by its bar rules to actually have contact. So there were no witness statements. There were no witness statements, and that party put actually the absolute majority of the 27 witnesses. And the other party made a lot of noise, just as much as you do right now, about how are we going to prepare? How are we going to cross-examine the witnesses? And it was amazing. It was crazy, I agree. 27 witnesses. It was like a doctor's appointment, waiting room, your therapy. I mean, this is really something that was quite impressive, but it worked. And I can tell you, the questions were put straight to the point. And you have to give the tribunal a little bit more, I would say, credibility and also capability. They understand what the points and issue are, so they can also put the right questions. And as a prepared counsel, you should know what the other side's witnesses are going to say, because we're not saying it's a blank. They will give context to the subject matters. And on those subject matters, you can prepare yourself. I mean,
And I get the final word, Panos?
You do, Councillor.
Thank you, sir. I'm going to address one point to Tiffany and one point to Niusha. And of course, I respect them and what they're arguing greatly. To Tiffany's point, she says, and now I don't want to be accused of putting a straw man argument. She said exactly, I read it with a grain of salt. I don't read what's relevant. We know that. We all lawyers know that. We don't put in witness statements that the tribunal are going to look at and think, oh God, this is rubbish, right? Think about it. Think about all of the times you've drafted a witness statement. Have you put in stuff you're like, this is not relevant, I'm going to put it in? No. Have you put in stuff you think the tribunal never going to believe this? No. You'll look at how it fits with the other witnesses. You'll look at how it fits with the documents. You'll talk to the witness and say, what's your real story? So I disagree wholeheartedly with the concept that we as lawyers or witnesses will put in things as a matter of course that one arbitrator or another has to read with a grain of salt or say, I consider these generally not to be relevant. To address Niusha's point, there were words that she kept saying, not allowed, not allowed. And I'll take you back to my points on party autonomy and due process. And what we should be saying is, what is it you want to say? Because the fundamental point is, at the end of the day, cross-examination works. It works for hundreds of years. There is no limit on tribunal questions. We have all been in cases where the tribunal questions have gone on for ages, right? They'll actually stop the cross-examination and say, I got so many questions. Can you guys stop? Right? Not to me. Well, once. but they'll say, we have lots of questions. And they'll go on for ages with questions. So there is no limit to the tribunal questions. The system doesn't say it's either cross or inquisitorial. It's either adversarial or inquisitorial. It's both. And it absolutely depends on the parties and the due process. So again, we would ask you to vote against the motion, because the motion is that the system doesn't work and we have to throw, as I said, the baby out with the bathwater. We don't. Happy to tweak the system, but the system should stay as it is.
Thank you very much, Baiju. Yes, please. Thank you all very much for your excellent presentations. Now we're going to open the Q&A session. Just before we actually do that, can we have again a show of hands to see who has been convinced one way or the other? So who thinks as of now that witness evidence will no longer be fit for purpose in 2032? Who thinks the contrary? So I think it's a tie, but with a bit more people have voted against the motion. So I guess it's Baiju and Gloria.
But we have to have the Q&A panel.
Yeah, we still have Q&A.
Because that could sway it.
Okay.
Yeah.
All right.
Very thin margin you've got.
Yes. So yes, now the time is for you to ask any questions you would like. So perhaps you, sir.
You can all hear me, right?
Yeah.
Very interesting discussion about due process, psychology, procedure. The one thing that was entirely missing from the debate, given that we're talking about what's happening 10 years hence, is the effect of technology.
I agree. Mhm.
So I can tell you right now that there are technologies today that can tell you who has written a written statement, who has written a particular piece of writing, whether someone has told the truth with a relative amount of accuracy, more so than human, and even whether someone's memory is fallible or infallible. So can I please ask you to assume that in 2032, these will be viable, common technologies, and ask you to take that into consideration and tell us what effect, if any, that would have on your respective positions. Thank you.
Is this with or without taking into account data protection?
Oh, good.
Yeah.
Very good. Thank you. Love that. Okay. You guys have the burden. You go.
I think a lot of
I'm
these.
telling you, I slipped it in that you had the burden. I don't know if you do or not.
Yes.
You can accuse me of that too.
No, I think that those technologies are. Here's the thing. I think the technology will arrive sooner than people are prepared to implement it. And I think that people will find it scary. I think that people will find it. I mean, my question is, lie detector tests exist, right? Their efficacy and accuracy is in question, right? Sometimes. And I think also that people themselves freak out so much that they may mislead the test inadvertently because, I mean, I don't know about you guys, but even if I weren't lying, I'd be like, shit, what if excuse me, sorry. I just think like, man, what if I imagined that I had an apple for breakfast this morning? What if I actually ate eggs and I had the apple yesterday and eggs today and I'm not remembering, I mean, the whole process is already stressful enough for the people that are testifying. But I do think that those technologies are important. I think 10 years is a short timeline. I think if we're talking in like 50 years, I think that could be very interesting.
Well, the technologies do exist in some countries already, as you know, on facial recognition to say whether you are maybe a criminal or not. I hope we don't go there, but I think one thing is already here, and that is that the video with remote hearings and the psychology and psychological effect it has on witness testimony. Indeed, we had already these discussions maybe a year ago, latest, that there is a distance now between the testifying witness and the cross-examiner or the tribunal, and so there were concerns indeed to which extent is the witness sitting in the bedroom or I don't know, in some office, okay, but still in a very cozy environment. So very comfortable, not being put under a number of stress factors that are usually the case and given in hearing rooms and courtrooms. So what is the effect on that? And it's true, I think we are there already, but we haven't done any studies on this yet. So, but I do think it will come back because evidently remote hearings are here to stay. And so there is something to be said about it, that we have to be more conscious about the way of examination, if it has to be really done by the counsel, but also by putting questions to the tribunal, by the tribunal to the witnesses. So that has an effect. I don't know where we are right now, but maybe
one question that I have is how much of this technology will require the witness to go to a specific place. So they can't be in their car or in their bed, and how much maybe that will perhaps it can still be done remotely, but it will have to be done from a particular location, and it will add in back some of those stress factors. I mean, I'm speculating because, I don't know, but go ahead, Gloria.
If I may try to give you some guidance of what is happening in the international arbitration practice, and I strongly recommend you an article that I've been reading these days by one of our shark tankers, Robert Bradshaw. Maybe Robert is here. I don't know if he's around. Hello, Robert. Thank you for helping me to prepare. I thought we will deal with technology because it is indeed a very interesting issue that then again might have to go back and dealing with issues of due process in the sense, at least for me, with my Latin American practice of procedural economy, because there might be parties that even if, let's say, we have very sophisticated algorithms and you challenge the arbitration award, you might not have money to pay that expert, if you are that side that is limited in budget. But thinking of putting that aside, Nisha is totally right. Now, the present challenge, let's say we are in 2022, the present challenge is data, but also there are issues of self-incrimination that Robert points well in his paper. There is a lot of algorithms that are made by the white mind, and therefore there are issues of ethics and gender bias. Very interesting paragraph that I was reading about Amazon creating an algorithm to employ things, and obviously more women go on maternity leave, so the algorithm itself will employ more man than female. It's something they don't think, right? And something very interesting that I read from Robert, it was in 1986, Fennell versus Jerome, which actually happens. I have a colleague in Aberdeen that she does a lot of research on that. Statements under narcoanalysis, so truth serum, and obviously it was inadmissible. But now, if we go back to our arbitration practice, there might be scenarios where technology needs to be used where the witness, for example, has an incentive to lie, so sports arbitration. Then if you read the case law, there is no kind of clear message yet because it might be controversial under the applicable law. It might be that it doesn't add anything special to the already legal case given by the disputing parties. And therefore, I think I will give more than 12 years, or maybe 20, 25 years, because you will need to go back and implement that in the applicable laws or in each jurisdiction arbitration laws. And that's a huge challenge, but God knows it can happen. Also, due process under New York Convention might have a different meaning if we consider technology, but I do think there's a lot of normative challenges that will need to respond to the evolving technology, and that might not be kind of hand in hand. And as well, I do believe there are ethical issues that we need to consider.
30 seconds. One of my best friends is a criminal barrister for the last 20, 30 years, who said that since CSI Miami and other shows, every jury is looking for the forensic science and saying, okay, and without it, they're not guilty. I think there's a danger in using technology as a crutch, as an absolute truth, until the technology is not infallible. I think Gloria makes an excellent point. I think it's a tool, but I don't think it's a perfect fix. The second thing I would say is the difference between international arbitration and court processes. There's no subpoena power. So if I'm an arbitration witness and you're going to stick me on a polygraph, I'm not going to do it. Right? I'm not subpoenaed. So I think we have to be careful because, as every tribunal will say, thank you for being here. You've chosen to be here as opposed to you're forced to be here. And I think that's a big difference.
Thank you. We have a question from Rahul.
Thank you very much for those excellent presentations. Lots of people have asked, and something that Gloria mentioned was also that there was more extent arbitration process, but it isn't nothing that is in the process. What seems to reverse down to is let's call it two approaches. Right? You have the memorial style approach, and then you have the field style. And we heard a lot from you about storytelling. And we got into the two sessions as far as the storytelling And getting the two reasons to qualify. If, for example, you do a pleading score, then it's too late for you to score the test by the time it's taken.
Yeah.
And your witness statements are definitely more time. Just take the story of what we want to know. But in the memorial style, potentially the story that's not in court.
Just very briefly, I agree with you, and I don't have an answer, but one of the criticisms to the Prague rules is that in terms of timing, so for example, when they suggest the CMC substantive, it's very hard to pin down the right timing in the arbitration process where you could kind of really plan your whole or the rest of the arbitration process. And because that might help you to take a different decision of what is it that as an arbitrator and maybe as the parties they want to provide to the table of the process. I really don't have an answer, Raul. I do think I want to see it. I would like to see it in practice to see what is it the decision I would take. I have never used the Prague rules, but there is a very good article where they criticize the Prague rules because of issues of timing, and it might be just too late to make those type of decisions already. What is the best legal strategy? Yeah.
I would just add, Rahul, I think you make a very good point, which is, but then I think the discussion moves to whether a memorial style versus a pleading style is better, as opposed to having witness statements or not having witness statements. That's a good discussion.
Yeah. Although, I think that the skill of the advocate is not only in the oral pleading, it's in the writing of the memorial. So a really good submission, now to bring in another term, is really when the story from the first, not from the request or notice of arbitration, but definitely with a statement of claim and then statement of defense already has a nice story to it. And that's why, for example, I love introductions without 5 million definitions already in it, if possible, but because you need to know what is that party's story. And I think that can be achieved in writing just as good as orally. Because I agree with you. At the hearing, it's too late. Even if there is a myth, to stick with the words, that arbitrators don't read anything before the hearing, but that's of course not true. So you want to make it as interesting as possible, as soon as possible.
Yeah, I don't know that I can add much to what's been said, but I'm a big memorial style proponent. But I do think, one of the criticisms that Baiju had earlier was, how do you know what's going to be presented? And what we kind of envisioned was more, you would have a memorial and you would say, or even in your pleading and note, this witness can testify to this fact, instead of having a full on witness statement, right? It's like embedded in your pleading / memorial or whatever style you're doing. But it is indeed too late to begin to craft your narrative by the time that the hearing comes, way too late. You've got to jump. You have a very short amount of time from a psychological point of view to grasp an arbitrator or indeed any listener to any story. You've got, 10 seconds, right? So you need to make that impact quite quickly at the beginning and not wait till you finally, it's way too late.
Great. One final question, perhaps. We have two people, so perhaps you, but then if we have time, we will come to your question as well.
Hi, I'm Lydia at Edinburgh in Hong Kong. I just wanted to confirm the theme about technology and the issue of anonymity, and don't feel the need to answer this from the perspective of your debating side. So I was wondering, using more of the blockchain technology, we're more and more used to transacting and others engaging in ways that are anonymous or pseudo anonymous and difficult to find. And we're seeing that some article rules, like the UK digital dispute resolution rules, are now allowing parties
Yeah.
I'm slow.
What are your thoughts on that? Or do you- what does that
I'm like, no.
process? Could we tolerate it?
So I have to say it horrifies me.
Yeah. Yeah.
One of the core due process issues is who is saying what, and I am entitled to ask why. If they're anonymous, I don't know who's saying what and why. I think credibility, I think impeachment evidence, I think that's critical to the process. It's one of those where, look, technology is a good thing, but there are certain times where it actually is not good, right? Where it's dangerous. We've all seen the movies about the robots going crazy and taking over the world, right? I think it's one of those things where anonymous holograms who can just say what they want without repercussion or consequence, or I think it's a very dangerous thing for a system of dispute resolution.
Yeah.
Well, that's different, right? So I've had cases against governments where I've had expert witness who have said that if I testify telling the government who I am, there will be serious repercussions against me and my family, and the tribunal accepted an anonymity. But even in that case, the law firm was entitled to know who they were, even if the client government wasn't, and the law firm had to give a representation that they would not disclose the name to the client. So that way due process was protected. So yeah, so thank you, Katie. You're right to say there could be nuances to it, but generally speaking, I think we have to keep my two pillars of party autonomy and due process always in mind as we move towards this ever increasing use of technology for dispute resolution.
In the interest of time,
Yeah.
I actually agree with Baiju. Not on the last point, but on the But I think, please.
Yeah, let's take the last question.
I mean,
Can I say something?
go ahead.
The first time I was appointed as witness expert, that was my first calendrum. And I mean, you heard my bio. I am an academic, but there are plenty of us. And I think if you don't want that is your only appointment as an expert, you need to make sure everybody's watching, right? Even if the arbitration process is confidential. So you have to do, obviously you have a name and you're making a business and you want to be sought. So you have to hear what are the concerns of that lawyer that is hiring you on behalf of their clients. But it's very important to uphold, we all have certain standards of ethics, professional ethics that we have to obey and follow, regardless of which type of expert you are, engineer, doctor, academic, lawyer. So I do think that while there is a commercial incentive of aligned to a certain legal ideology, if you want, or a legal position, I do think it is very important that if you don't want that is your first and last kind of consideration in the market, you really need to stick to the law, obviously. Well, I was a legal expert, so I had to look into the law. And therefore, I don't know. And you are actually assisting the tribunal at the end of the day. So, right, experts, regardless of, I think that's very important. We remind experts, either witness, fact experts of witness experts, whatever, witness experts or fact experts. I think we are assisting the tribunal. We are really clarifying a point to the tribunal. And that is really something that maybe lawyers should remember. They're experts, like, you are there to to assist the tribunal. We are not really to align to whomever is hiring you. I know it's maybe commercially speaking, there are a lot of calendrums in there, but that's very important. But I don't know. I thought about it. The first time I was appointed, I was like, oh, I really want to be an expert again. Where are my ethics? Where is my code of ethics? It's very important.
We were not supposed to talk about expert witnesses, so that's why we didn't actually mention it at all. But I can give you a number of household names to law firms. So the law firm's always going to the same expert on anything and everything. Of course, then it's also business model, talking about commercial means. So, but whether then really the credibility of that expertise is so high, that's another question. I find it rather sometimes insulting to the tribunal.
Of course.
Yeah, I think it's incredibly coincidental that some experts can find a DCF for billions and billions on a speculative venture, and other experts conveniently, every time they're appointed, find that actually they've done the other side a favor by expropriating the asset or breaching the contract because actually they saved them money. Pure coincidence, I'm sure.
Yeah, no, it's very important.
Yeah, no, it's not an easy,
Well, thank you very much. This concludes today's debate.
Yeah.